The United States Supreme Court decided a decision in 2002 called Alabama versus Shelby. That case basically said that it is constitutionally mandated that if someone has a potential liberty interest at stake, that representation is provided to them. As I stated, we have not provided magistrates court representation. Out of the 16 different judicial circuits within South Carolina, we are one of only 4 judicial circuits that does not provide magistrates court representation. I can tell you last year there were approximately, from what we could figure out, at least 400 individuals that were incarcerated in our local jail through magistrates court, although those numbers are kind of subject to question because that did not have anything from, or did not have any numbers from CDV court. And Ed Lewis with the magistrates court tells me that people are quite often incarcerated through CDV court. Ultimately, I can tell you one of our other concerns, and if I might, Mr. Chairman, we have a letter that has been sent to the magistrates I'd like to pass out to the council members. This was a letter that was sent, I believe, to our local magistrates and also to the Commission on Indigent Defense from the ACLU that is kind of gives a background of Gideon and also the representation of magistrates court within South Carolina, which obviously concerns us. I can tell you a few years ago that they had threatened to sue Oconee County over the lack of representation. I think I've kind of told everyone, quite honestly, I would wish we didn't have to be in magistrates court. I certainly have a full plate as it is now, but it is something that is now constitutionally mandated. We are not providing that service, and we certainly need to be.